Yo, what's up, fellas? Peace. There you go. Sham stoppers. Ho! What's up, the other person? I know it's another person in here. I'm about to start putting stuff up. Hold on. We're gonna start talking about the age. We're gonna start talking about this agency first. I'm glad y'all look, because I'm gonna tell y'all something. This country's at a world divide right now. You got you got the Muslims and the Jews when they go to war on this motherfucker. They finna go at it, nigga. I ain't got no beef with no Muslim. Okay, I ain't got no beef with y'all. Uh, hey man, I thank God I'm not Jewish. Um, I seen a lot of deportation stuff. I didn't see a lot of Muslims get deported out here. You know what I mean? And I think we're gonna have a civil war, so. But in between time, it's time to get your lawsuits in before the civil war kicks off. Right? Time to get your lawsuits in before the civil war kicks off. You know, war between the Muslims and the Jewish people. And, you know, I ain't got nothing to do with it. Sham stoppers, ho! There you go. Fellas, it's gonna be another good one tonight. So I'm gonna try to be quick and fast about it. You're gonna love it. This one gonna be a little bit better. They're gonna get better and better as the time progresses before the Civil War kicks off, because I see it coming. And be weary, fellas. Don't get scammed. There's gonna be a lot of scammers out here coming after you. There's gonna be a lot of animosity. Now it's in the air, man. I feel it in the air. Everybody going through something right now. You know, I just got my seatbelt on. I'm enjoying the ride because ain't nothing that bad. So let me start putting some stuff up. All right. Wait till we get to the Levy stuff. Now I'm gonna put this up for y'all. Let me put this up for y'all. Let me present this, share this, and I want y'all opinion. I want y'all think about this. Y'all see it? Y'all see that? Huh? At will, termination of agency by either party. Any agency relationship is generally subject to termination. Subject to termination. At will by either party at any time before performance, with or without cause. Absent of specific agreement or special circumstances reflecting contrary intent, an agency agreement is ordinarily terminable at will, absent provisions for duration or termination. An agency agreement for an indefinite, unspecified period is terminable at will by either party subject to good faith. Y'all see that? Tell me what y'all think about that. Huh? Tell me what y'all think about that. And I'm glad I got the only two people that's be in here to read. Everybody else can't read. A lot of these niggas is fucked. A lot of these niggas is cooked. You know what I mean? I'm only helping a few good men here. Let me go to let me go to the next slide. Let's go to the next slide, fellas. They'll catch up. Y'all see that? Governing law of agency. An agency is generally a matter of common law, but may be statutory in nature. Statutes employing terms of agency are presumed to incorporate the established common law meaning of the term. Generally, the governing law is the law of lex loci contractus, which is a contract of the state in which the contract was made. Absent contrary choice of law rules by another law viewed by governing law is the law of the state which has the most significant relationship with the parties, the occurrences, and the contract. Y'all see this shit? And go to the next one. How does that work if you never contract with the agency in the first place? Correct. Okay, let me keep going. So it's legislative in nature. While there is contrary authority, rulemaking is considered to be legislative or quasi-legislative function because it largely concerned with questions of policy. Y'all see that? Questions concerned with questions of policy, not questions of constitutional law or your rights. Fellas is getting railroaded right now because they think that child support is the end all be all law and they think it's what is it? Death row. Keep going. We about to get to the good stuff, fellas. We about to get to the good stuff. I got two more of these slides, and we're gonna talk about the source of power. Their source of power. Well, child support get their sources of power from. This is child support source of power. Being creatures of the legislature, administrative agencies have no general or common law powers. That's why the administrative, you have to give them permission to administrate your trust, your children, your property, all that. But only those powers conferred upon the statute or constitution, right? An agency must act in accordance with the applicable statutes and its own regulations. It said it must act with the applicable statutes, not the constitution, right? Because how would that be fun for them not to make money off of you or fool you for being an idiot, right? Real talk. Hold on a second, fella. Apart from the instances where administrative agencies created and empowered by a provision of the state constitution or an executive order, not a judicial order, but an executive order. The source of powers of administrative agency lies in statute, and an administrative agency must find within the statutes warrant the exercise of any authority which they claim. They don't have no power, fellas. They only have power when you take your ass up in there and you play their little faggot ass game. You know what I mean? Told you I was coming back tonight, didn't I? The election of administrative process to legal process. Administrative agencies belong to a different branch of government than judicial court. What have we talked about? What have I talked about 3 or 4 podcasts They're what? Specialty court. They're not judicial. They stand by themselves. Out here in Austin, they have their own family court building. They're not even part of the building on Guadalupe Street or the federal court down the street on Fifth Street. They are separately created and exercise executive powers and administrative legislative authority, not judicial authority, but legislative authority. Legislators come from the people, us. We have to vote on them to do this shit, right? If you didn't vote, guess what? It doesn't apply to you. No one can speak for you. If they can speak to you, they need to be paying your bills, sucking your cock, washing your balls, washing your car, giving you money, taking care of you, right? That's what happens when people have authority over people they take care of, delegated to them by statute. An important goal of any administrative scheme is to guarantee the rationality of the process through which results are determined. The administrative system substitutes administrative agencies for courts in making many determinations and establishment and definition of individual rights. Let's read that again. The administrative system substitutes administrative agencies for courts. Nigga, and making many determinations in the establishment and the definition of individual rights. So what they're saying is they just make up shit. They make up shit for you if you don't stop them in their tracks. Guess what? You giving them power, which is implied and expressed power. You got to stop these people in their tracks, right? Administrative procedure is really simple, less formal, less technical than judicial procedure. So this is not child support is not a judicial procedure because guess what? They don't go by that. They in it for the money. They are all contractors, i.e. Kevin B. For instance, strict rules of evidence generally do not apply to administrative proceedings. Look at this shit. I'm gonna read it again. Strict rules of evidence generally don't apply for administrative proceedings. What that means is your bitch ass baby mama can go online and say you abandoned her, you ran her off the road, you did this and do that. They don't have to have any hearsay works in this court because guess what? They represented her, they contracted with her to get money out of you, right? In addition, the right to a jury trial in suits and common law preserved by the Seventh Amendment to the United States Constitution is generally inapplicable and administrative nigga. So these niggas on YouTube telling out to my I want a jury trial. I request a jury trial. You can't get that because they already said this ain't a judicial court, nigga. Man, it's gonna get better. Y'all watch this what I'm gonna pull up next. Told you I'm bringing this heat. I'm bringing this heat, man. Ooh, here we go, fellas. Here we go. Cause ain't as good, ain't reading good fundamentally. Ain't as good for your mental, huh? Let me see, can y'all see that? Oh yeah, y'all can see that. Oh yes. Oh yes. Oh yes. Oh yes. Look at this, fellas. Oh, 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 here we go. Attachment and garnishment, writ or warrant of attachment. And adjourn. Nature or purpose of issue adjourn. The writ of attachment through containing a clause of a summons and through usually the commencement of proceedings is really more merely allied to final than to men's process. It is substantially a writ of execution, except that the emanates at the beginning instead of the termination of the suit. It is object to seize and to seize and hold property subject to the claim sued and on and to satisfy them. Failure to index an attachment entry in an accomplished book is not fatal to the lien, although an index is required by law where the statute changes the old law by which the return was sufficient record requires an interest of attachment, but does not mention the index. That's a bunch of dumb legal confusion, right? Court in place of insurance. The writ may issue in a court having jurisdiction of the action. venue or the proceedings of attachment has been treated in the previous section. Who may issue? The person authorized to issue a writ of attachment is usually the court, a judge. The court can't issue shit. Only a man or person can do that. A judge or the clerk of court. The authority vested in the official to grant the writ of attachment is simply ministerial in its nature. Do you hear that? And where the ground of attachment may be alleged in the language of the statute, the authority to allow the writ need not to be exercised by the judge of the court, but may be delegated by the legislature to an official such as a clerk of court or a probate judge. Thus, in the same space, the writ of warrant of attachment is issued by the clerk of court in a ministerial capacity. Fellas, when they do things in ministerial capacity, just when you can sue them. I got plenty of case law on that. I got the shit over here, nigga. This is why we so successful over here. In other jurisdictions, justices of the peace are vested with such power. Okay. A writ of attachment, which is regular on its face, is presumed to have been properly issued and may be offered in evidence without proof that the steps primarily to its issuance were taken in prescribed manner. Where a writ of attachment is lost or destroyed per evidence and its content service return is admissible. Bro, it's gonna get good, fella. Hold on. Move that one. Here we go, fellas. Y'all gonna like this one. I helped somebody on here with this shit. I used this book I got. Execution of the attachment journal. Generally, the execution of attachment is taking property to legal custody of an officer by virtue of the directions contained in the writ of attachment. The taking of the property to legal custody involves the levy of the attachment on the attached property and the actual constructive seizure of the same. The levy alone does not give the court whence the process issues either actual or constructive possession of such property. Person can make levy. As a general rule, limit attachment can, let me go to the next page. Here we go, fellas. Ooh, can be levied on by the officer to whom it is directed, who of course must be by law duly authorized to act. An attachment by an officer without authority of law being no attachment at all. Do y'all understand that? So when they be levying niggas shit at the bank, right? The sheriff's supposed to be handling his hands, fellas. Let me keep going. The sheriff is ordinarily the proper office to execute a writ of attachment. How many sheriffs executed writ of attachments on y'all? I'm feeling like spilling the beans on all these people. I don't give a fuck. I really don't. And it's protecting and making a levy under a writ which is valid and regular. However, full of his knowledge must be of insufficiency of the cause of action on which the writ issued, or of wrongful and malicious intent of the party ensuing out the writ. Also, the writ of attachment may be generally be assigned to a deputy sheriff to levy, in which event the deputy acts as his principal and has all the powers which may be exercised by a sheriff in serving and executing process. So have you ever called the bank when they say they levy your shit? Did they do this? No, they did not, fellas. It's all fraud. In some cases, the coroner is duly empowered to execute a levy. Where the writ issues from federal court, a levy therein is made by a marshal. A constable has no authority to make a seizure by attachment unless specially authorized, and a seizure made by him without being so authorized renders the whole proceeding nullity. So if the constable tries to do a levy and they not authorized to do that, fellas, guess what? Null and void. However, a constable acting in his scope of his authority under the valid process is such an officer of the court, out of which the process issues and the property seized in it is in the law's custody as efficiently as through the acts were performed by a sheriff of state court or marshal of federal court. This is, hey, this is delicious, isn't it? What that woman say on that child support thing? And what's it called? This is delicious. We'll be dropping these jewels over here. Look at this shit, nigga. Look at this shit. That no man shall be his own officer, and that no one shall in his own person or by his own hand do himself right by legal process. It has been held, however, that a sheriff who is a member of a vacant corporation may serve process thereon because not being personally liable, he is not a party to the action. Y'all heard that? In many jurisdictions, it is provided that when the sheriff is a party to this action, a writ of attachment execution must be directed to the coroner of the county, to the coroner. Levy outside the state. Here we go, fellas. The sheriff of one state may not levy process issued by the courts of such state on property uh, situated in another state, as no state tribunal can exercise jurisdiction over persons or property within the borders of another state. Did you hear? Did you see that? I'm gonna let y'all figure that one out. Moreover, by the rules of common law, the sheriff of one county has no authority to levy an attach or execution or seize property or honor situate in another county, right? So this what happened to me about with a ticket though. So Williamson County is another county over past Pflugerville. I had a ticket over there, and the constable tried to come serve me, and I'm in Travis. And he couldn't do that, and I knocked that shit down. I went to the law library, found his jurisdiction. They knocked that shit, dismissed that ticket. That's how I do the ticket, fella. But anyway, the legislature may, however, confer power on sheriffs to levy on and sell lands not lying within the county. Fraud. Levy affected by unlawful or fraudulent means. An attachment is void if an officer unlawfully and fraudulently gets possession of a debtor's property and then attaches it on the next process. The general rule is that an attaching officer has no right to attach articles worn on a person of the debtor as part of his dress or apparel at the time of the attachment is made, nor is money or property in a man's pocket liable to seizure under attachment. Then we watched that court thing the 2 weeks ago where that bitch said, "Give me the money out of your pocket. Give me the money out of your pocket. I want that money. Go get that money up." She seized and took that money. She wasn't supposed to do that. He don't know his rights. A different role have a gun corn carried in the bag held in the hand, or a horse held by a bridle, both of which are said to be attachable. Also, where a property is fraudulent or forcibly removed or procured to be removed by a creditor from one state into another for the purpose of attachment, the attachment will not be permitted to stand. I'm giving y'all these remedies tonight. Say ho! Similarly, with the sheriff of one county having it written in his hands for the service against the property of a debtor finds such property in the later's possession in another county, and stating to him that he has an attachment against his property, takes possession of it, conveys it into his own county, and then makes a formal levy. Such levy is void. You want me to break that? Let me break it down. So if he got a homeboy, another sheriff, say, hey man, I got this property, man. I need you to do this shit so we can take it and share it. All right, I'll take it. Let me see can I levy it over here. That's fraud, nigga. An attachment of property taken by an officer from the person of one arrested from the commission of a crime is void. Y'all heard that? An attachment of property taken by an officer from the person of one arrested for the commission of a crime is void. It has been held that if the officer took the property simply for the purpose of getting possession of it so that he might attach it on which he then held or expected to receive. All right, let me stop this. Yes, bro. But if he took it in good faith to secure the safekeeping of the prisoner, an attachment of it by him on a writ which then comes into his hands is valid. You got to do it in good faith, though. In such case, it's a question in fact for the jury whether the officer who took the property from the prisoner arrested in the commission of a crime acted bona fide or for the proper purpose of malified and for improper purpose. So check this out. So you get arrested, right? Well, when they spoke patent frisk, right? And you didn't even give them permission to go on your person, right? That's illegal. He can't take your property. That's just like I don't know if y'all knew this. If you get pulled over and they trying to tow your shit, right? Uh, uh, for a false infraction or something, they trying to tow your shit, and you tell them, "Hey, I got somebody to come pick it up." So just wait. If they tow it anyway, say, "Nah, I'm gonna tow this." You can sue them in federal court. That's a lawsuit. When levy should be made, the general rule is that an attaching officer must levy a writ of attachment as soon as he receives it, as the nature of the case will permit. According to other courts, however, a sheriff is bound to use reasonable diligence only in executing a levy, and what constitutes such diligence depends on the particular facts and circumstances of the case, as for instance, whether the writ is for fraud or because the defendant is about to leave the state or because he is about to remove his property. The general rule is that the levy on Sunday is void, and a writ placed in the sheriff's hands on Sunday cannot be officially received by him on that day. It can only be considered official in his hands when Sunday has expired. A levy should only be made on the daytime, but it often be that a levy can only be made at night. However, when a sheriff or other officer goes without any previous attempt to levy at the late hour of the night and thus unnecessarily intrudes on the rest of the debtor and his family, his action may be held to evince a wantonness which may make him a trespasser from the beginning. Nigga, this nigga can't do this shit at night. What y'all think, fellas? This was a good late night ass whooping. This was a good late night ass whooping. And you know what, fellas? Y'all have a good rest of the night. I enjoyed it. It was good. You come in here late, you watch that motherfucker. Peace.